Сейчас настоящие новости важнее, чем когда-либо прежде. Поддержите честную альтернативную точку зрения, ток-шоу в прямом эфире. Ваша финансовая помощь будет способствовать возрождению журналистики и поможет защитить наши свободы для будущих поколений.
yesterday at this time. We'll see how that grows throughout the day. Kind of recap what we a couple of issues. So at the end of the day, we still don't have any conclusive verdict on what will happen. What will happen today? We're not sure. About an hour ago is when deliberations for the second day kicked off. We're about an hour and 7 minutes into that. We have not had any notifications coming from inside the courthouse. We haven't had any updates as far as the instructions from the judge. Now, I will say that what I've learned over the last few hours is if a verdict is determined today, typically they will give an advance notice to the public and to the media that a verdict has been reached in order to essentially mobilize the National Guard, who is about an hour and a half away from this location here, and that is in preparation to whatever way the verdict goes in this court case, that they have ample time to set up a perimeter and help deter any type of violent activities. We saw last night there were some demonstrators outside the courthouse here, obviously very vocal in their opinions. I would say 95% of the people here feel like Kyle Rittenhouse is guilty of all counts charged against him, and you do have a few people here today, like yesterday, that feel the opposite on that. Now, what has developed over the last few hours overnight is an extreme demand for security, not just for the judge and for the prosecutor and the defendant attorneys, but also for the jurors. There've been some videos, there've been some chatter amongst social media of jury intimidation. That's something that you don't always see, but of course in a very high profile case like this, that is certainly something that can come up. This is a very emotional court case. I said this yesterday. I feel like a lot of the people out here protesting haven't really watched that much of the testimony coming out of the trial. Perhaps they're getting a lot of the information on social media and other sources that are unreliable. Also breaking was the use that the prosecution released a video, a drone footage, as evidence that was a low quality type of video footage from that drone shot. But when they had a very high definition version of that footage, they withheld that evidence, but instead giving them the very low, more of a granular viewpoint from that, very fuzzy, very difficult sometimes to make out things when there was a very high definition version of that. Don't know how that will play out, but that is something that was brought up here overnight as well. But as far as the security is concerned, that is probably one of the biggest issues right now in terms of this case, in my opinion. Just talking to some people offline here before we started, is that's a serious thing. This is a very small town. This is a very small town community. It feels like everybody knows one another. So there's a chance that those jurors that are sitting inside there know many people that are outside here. And so there is a level of intimidation as far as either way that the verdict can go. If he's found not guilty, there's intimidation there. And of course, if he's found guilty, obviously there is major intimidation there. You got the judge as well is under personal security. We've got the defendants, the prosecution, everybody involved in this case is just under a giant microscope right now as far as security is concerned. Now, security here on the ground, I will say, they've got a decent amount of police presence here. I anticipate that to increase as the day goes along, as we get closer to a verdict. And of course, your guess is as good as mine when that might come. But from what I understand with local authorities here, if they will announce what time a verdict will be released in order to mobilize law enforcement in here to make sure that they secure the area and have a peaceful protest. And at the end of the day, I think a lot of people here simply just want a peaceful protest. And of course, we talked to a lot of people yesterday out here on both sides of the aisle here from the legal system. A lot of people feel like Kyle Rittenhouse was reckless and had an intent to kill with the AR-15. And then you have a lot of people here, a few, that think that Kyle Rittenhouse simply was exercising his Second Amendment right to protect his livelihood, so against the threats that he faced. So I think that's one thing that's interesting in this case, that it's not necessarily a racial case, but it seems like the media and a lot of people here have made this very much a racial case. But indeed, it's a white kid, a 17-year-old at that time, shooting and killing two white men and injuring another white individual. So this is not a black or white or even a racial thing, but it seems like yesterday white supremacy was thrown out. And of course, we've seen President Biden at times before the trial label Kyle Rittenhouse as a white supremacist, and we've seen many mainstream media outlets say this same thing, as kind of paint this kid as some white supremacist that came out here on that 25th of August 2020 to do bodily harm to people that were here. Drove up from Illinois to Kenosha to protect local businesses. That's his story. Now, they did a big deep dive into Kyle Rittenhouse as far as his social media goes, his phone records. There is no ties to white supremacy from that standpoint. There's no factual ties to white supremacy from Kyle Rittenhouse. So that label, I think, is a very misrepresentation of what's going on here. It's more of a Second Amendment right to protect yourself against bodily injury. And that's something that the jurors have to decide for themselves. I mean, they've had this trial kicked off just the 1st of November. Here we are later in the month in day 2 of the deliberation. So there's a lot of evidence that they've had to go through to make that determination about that. Also, we talked to Mark McCloskey yesterday, of course, running for Senate. You might recognize that couple. They were very synonymous as far as taking a stand against their home and in St. Louis, coming out on their lawn with firearms, aiming it towards the crowd that was coming through their house. We had a few minutes to talk to them, and then we had an interesting dialogue that I tried to facilitate between a community leader that was here, that was asking very pertinent questions to Mark McCloskey as far as what does he plan to do to bring the community together. And I think we had an encouraging dialogue between that community leader and him in that regards. And a lot of concern here on the ground is that there's people in the black community that don't necessarily have a heartbeat or understanding of what's going on here on the ground, and there's a little disconnect of information, and that's something that is very concerning to community leaders here in the area. So there's a lot of different dialogue taking place, a lot of misinformation being put out, but at the end of the day, they want justice here on both sides. They want to find out exactly what happens, and we have the best judicial system in the world. Of course, there's countries that strive to have the types of checks and balances that we have in this country. If you look at the George Floyd trial, the wheels of justice turned rightfully so in the eyes of many in that court case. And so it's tough to criticize whether or not the judicial system's playing out here properly, but it didn't play out properly at another case. That's yet to be decided. Let me step aside, set the scene here. Like I said earlier, decent crowd has shown up. It's early. Weather conditions, it's a little warmer than it was yesterday. The wind has picked up. The temperatures have dropped here in the last couple minutes. We recognize a few familiar faces from yesterday. I'm sure more people will come out here as well. Media-wise, as you'd expect, another day of a huge turnout. Mainstream media obviously is covering this case. We've got news outlets from France, Germany, and other countries out here keeping an eye on this case. This is not just something that people here in the U.S. are watching. This is worldwide here in Kenosha. So we've got a solid police media presence here. That is the front entrance of the courthouse. Of course, we saw a lot of the speakers that were assembled there yesterday. Kind of a pep rally, if you will, of encouraging support on either side. Hey, I want to jump in here real quickly and talk about our good friend over at Mike Pillow. Mike Lindell, yeah, Mike Pillow. It should be his name because you got a guy that has really stepped out and has stood for justice. He has stood for election integrity. He has stood for the American people and then put America first. And so let's go protect his company, let's protect his rights, and go over to mypillow.com. And let's get ahead of the holiday shopping and the stress of going to malls and hopes that you get your products shipped and delivered to your house with all the supply chain issues going on and just the hustle and bustle of the holidays and the stress. Go online to mypillow.com, and put that promo code RSBN at checkout, and you'll get up to 66% off. Liz Willis and myself was back at that factory about a month ago. Had just another inside look at how they make those wonderful pillows and the most comfortable pillow in the world. So go check it out at mypillow.com. That's mypillow.com. Go check out those Visa sheets, maybe the flannel sheets, perhaps slippers is something that you can put in somebody's stocking this year. Definitely go check that out. And you know what? In full transparency, when you buy something from mypillow.com on my store, a portion of those proceeds goes right back here to this network to enable us to continue to spread the news of what's going on in our country. Huge streams yesterday, thanks to you guys across all of our platforms. So big thanks to that. So go check it out, mypillow.com. That's mypillow.com. Don't forget about that magical promo code RSBN at checkout, and it'll get up to 66% off. I'm going to see if I can walk over here. We've got a couple, and you can just stay there, Joe. I'll walk over here. We've got a couple people that have assembled. A familiar face, we talked to her yesterday. One of the ladies that had a sign that said Antifa and BLM are here to intimidate. I later saw her sign. But I want to get your point because you really, they ripped your sign up at the end of the night, and you made a new one. But let's talk about how you remained peaceful. a few familiar faces from yesterday, which is we knew they'd be out here. I actually thought more people would be out here at this time right now. Don't know why that's not at this point, but we're back out here. You're out here, and I think you said something earlier, the importance of prayer in a time like right now. How can that heal us? What part does prayer play in all of this?
For one, it plays as hope to a lot of us, and it also is, for me, it gives me an armor, gives me a protection to know that I can walk today without being hurt, that I am carrying the light in the darkness, as a lot of us say. So,
well, God bless. Thanks for coming out here. Stay safe, and of course, hope everyone respects your right to opinion. That's what it's all about: is having a freedom of speech, and exactly, and you can hold this sign without getting violently attacked or something.
Yes, I appreciate you guys being out here and giving me time. Thank you.
Thank you. And that's one of the biggest concerns here is the fact of having the ability to have an opinion on this without getting attacked. I mean, she had a sign out here. We have video evidence of someone coming up to her and taking the sign away from her and ripping it up. And I wouldn't want her doing that to anybody else that was pro finding Rittenhouse guilty in all of this. Like, I think both sides need to respect each other's opinion and let the laws of justice play out here. To take a look at the area here, we did drive around Kenosha a little bit this morning and last night. I was told I would see widespread evidence of a lot of the riots that happened the summer of 2020. Quite honestly, I did see some abandoned buildings and some buildings that were damaged, but I didn't see what I thought would be the quintessential town that had been rioted through that we saw so much back in the summer of 2020. And one of the biggest conversations that have really come up out of all of this is that will this trial set a precedence that if there's any type of on the street looting and rioting, and we saw the buildings that were burning down, the stores that were looted, the people that were injured, both law enforcement agencies and other people. We saw all of that, and it seems like from a law-abiding citizen that I didn't see a lot of accountability in that. We didn't see a lot of people be arrested. We even had one community leader yesterday say that a lot of times the media covered up a lot of that. They love to exploit the situation for ratings. Obviously, video of people burning and looting and fighting police is one of those things that it gets high numbers on social media. And so they come out, they show all of that, they exploit the people. But at the end of the day, they're not helping at all. The media does play a role in all of this with some of the misinformation that comes out. And this is not a political trial. This is not a racial trial here. This is about your right to defend yourself and exercise your Second Amendment. And we saw the prosecutor in the courthouse earlier in the week with the AR-15 pointed it at the jury, describing his actions, and I think very recklessly at one point even having his finger on the trigger, which any gun owner knows that's absolutely something that you don't do. We saw that in the courtroom. I like to ask a lot of these people out here if they support burning down cities, if they support violence. I don't think violence is a means to accomplishing anything here. So it's going to be interesting to see at the end of this trial, either way it goes, what the reaction here on the street will be. We're all praying obviously for peace. We're praying for justice, and let the court system do what it's intended to do, and let the facts come to the case and not the emotions or misinformation. And of course, at the top of this hour, we talked about the security aspect in all of this, being the security of the jurors, the security of the prosecutor, the defendant, and even the judge in this case. This is a very small town. This is something that it's not very easy, or it's not hard, I should say, to disappear in a large population. So anybody that may be sitting on this trial right now may be a victim of intimidation. Of course, this jury was not sequestered They were not, protected from a lot. They were told not to obviously engage with the media or get on social media or watch the news. They were told that. Now, whether or not they follow through with those orders, none of us will ever know, but I can only imagine that if one of those jurors were to log on to social media and see some of the rhetoric coming out in regards to this case, it could be a little intimidating on that. I want to remind everybody to also check out our new app. We rolled that out about 6 months ago. It was top 5 app on iTunes. Go check it out, your Apple or your Android store. Download the RSBN app, absolutely free. You can take this show on the road with you wherever you go. We got Laura Trump, Diamond and Silk, Red, White, and Truth. You even got the great conservative talk show host is on there as well. Go check it out. RSBN on your Apple and your Android store, absolutely free. Don't forget to also go to our website, sign up for our newsletter. We are pushing out these newsletters, it seems like on a daily basis, as so much has developed in the world of politics, in the world of what's happening here, in the world of healthcare and COVID, the vaccine. We all cover all those topics. So go to our website as well, rsbnetwork.com/newsletter. Sign up for it. Put your email in there. It takes about 30 seconds. We're not going to spam you with stuff. We're only going to send out the newsletter. We have a tremendous, talented team of writers that are with us. So go check it out. rsbnetwork.com. While you're there, also, we know we've got some proud partners that help our network, but we also have proud partners like yourself. So if you feel led to donate to our network, you can do that at rsbnetwork.com/donate as well. Let me step aside and see what it is behind me. I know we got a few more people out here, and of course, the first time I've seen an American flag here, which is really nice to see. We didn't have that yesterday, though. I will say that we did not have an American flag yesterday out here, so it is good to see that as well. And I want to leave you with this. We talked about Mike Lindell. You might have watched the interview last night with President Trump. A great interview. He was teasing it on social media, had clips on social media, but we actually aired the interview with President Trump last night. So I encourage you to go check that out. But meanwhile, while you're at it, go to mypillow.com and pick up those towels, pick up those Giza sheets, pick up those flannel sheets. It's all right there on the website. And if you want to go and pick up an American flag as well, go to mystore.com. They've got thousands of very patriotic items there that you can buy for the holidays. And I've always said this, depending on where you live, if you don't have an American flag in front of your house, you need to have one. You need to put that up and display your proud patriotism and your love for this country in your front yard. So go check it out, mystore.com. Don't forget that promo code RSBN, and you'll get up to 66% off your entire order. mypillow.com. Now, we're going to be out here all day. Now, obviously, we're going to try to pop in at the top of the hour, give you a quick update of what's going on out here. Now, obviously, we'll keep you updated through social media as much as possible, what's happening inside the courtroom, as that stream is not provided to us, really to 99% of the journalists here. So we have to rely on a lot of social media feeds coming out of there. But we're going to let you know what's going on inside and outside, as we seem to be the only ones really providing an exterior look at this trial outside, because that's where the emotion's taking place. This is where the community activists on either side of it are coming together and having that dialogue and having the interactions here. So we're going to be out here providing that information for you. You can follow us on all of our social media. You can follow me at Brian Glenn TV across the platforms, Twitter, Facebook, and Instagram. And of course, follow Right Side on our Facebook, our Twitter, our Instagram, our YouTube, and of course our Rumble yesterday was incredible as well. So make sure, if you don't have Rumble on your phone, go to your app store and download Rumble and subscribe to our channel, and you'll get these notifications every time we go live. You'll get those notifications. You'll also get those notifications on YouTube as well. Subscribe to us on YouTube. And you'll get that pushed out. Newsletter, YouTube, Rumble, social media, we all got it right here. We'll be live here for day 2 of the deliberations in Kenosha, Wisconsin. We'll see you back here in about T-minus about half hour, top of the 11 o'clock hour here in Kenosha. Until then, we'll see you.
got all the attention you get in high school. You got all the attention right now. All that attention you get in high school. Now you got all the attention you want. Isn't that so cute?
You can park over there. You can go around the building and go down that way. That's fine. Hold on a minute.
Can we? Now that he's the one that.
Black Lives Matter is a terrorist organization. Black Lives Matter is a terrorist organization.
You can park over there. You can go around the building and go down that way. That's fine. Hold on a minute.
Can we? Now that he's the one that.
Black Lives Matter is a terrorist organization. Black Lives Matter is a terrorist organization.
not going to box you guys into accepting what I think is the better way, and I sense from the statements that have been made that I think that in some respects you may even agree with me that it would be better if the jury could. We're going to now have the jury will come down here to the courtroom, and everybody will be shooed out of here, as they should be. And I'm not even sure. We're going to have to review the procedure that's been outlined. But they get to watch it once. Is that what the rule is?
I think they should be allowed to view what they want to view as often as they want to view it.
Subject to my other objection, I don't have a problem with them viewing it multiple times. At a certain point, I don't think that's,
I don't think that's enough.
3 or 4 times, I don't have a problem to sit here and just keep playing it. I don't think that's the right way either. Then it's giving more emphasis to one piece of evidence.
Well, but sometimes there's one piece of evidence which is absolutely critical. And I talked about the Tsarnaev case. I talked about the attempted murder case that I had in here. And I don't know how we're going to police this anyway. And the other thing is when it is being policed and someone's watching them talk about it, well, can they freely talk? Which is what we want. We want freedom of expression between the jurors. And so as they watch these videos, and to me, if they want to watch it 100 times, that's them. If it were a bench trial, and I've said this before, if this were a bench trial, and I put in my decision that I thought that Exhibit 486 was critically important, but I didn't want to overemphasize concentrating on it, so I left with questions in my mind about it and decided I better not look at it anymore. I should get reversed. That's an outrageous thing. But that's what we're forcing the jury to do because of the disrespect that the courts have had in this country for the juries. These are intelligent people. They get treated like there was a time when the educated people in the town were the physician and the lawyer and maybe the school teacher and the preacher, and the rest of the people were farmers. So obviously they weren't as smart as those educated people, right? Wrong. That's never been the belief of the founders of our country. It's never been true. And I think these people are as competent as the educated people, and many of them are educated, to make these decisions. And that's where the founders of our country put the power, not with us. So I think it's insulting to the jury to tell them that they have to have these restrictions on their viewing. But we're gonna sit down with the books. We're gonna find out what the exact procedure is, and we'll await what they want to do. But for now, I will answer: do we view the videos in private or in the courtroom? And the answer will be in the courtroom. Do you need to know the exact exhibit number or video or photo? Well, there's 2 options. One is we can just, you can have all of them. Anyone gasping? You can have all of them. Whatever you want, you can pick and choose, and you can, or you can describe generally what you want.
Yeah, I think the exact exhibit number would be helpful, but if they can give us just a title or a description, we can also figure it out. I agree.
All right, so what I'm going to write, you've got copies, so what I'm going to write on here is in courtroom. I better write it in a pen. General description. General description of what you would like. Is that all right?
Yes.
The only thing I would ask about with regard to your answer, Your Honor.
Yes, sir.
I'm not sure I heard you correctly about if we bring the jury back, you mentioned something about kicking everyone else out of the courtroom. And I don't know what you're planning to do, but if you are planning on doing that, it might be helpful to tell the jury that so they understand that they would be viewing it without the public around. I don't know what you're planning on.
That's a good point. Except that I don't know exactly who are going to be the kickies. Certainly all the media and the officers, other than the media and the officers, and the question is whether the lawyers and the defendant. I don't know what the answer is. We'll have to check that. And I don't know if I'm supposed to be in here. I got the impression, and it's been a long time since I've read one of these cases, I got the impression it was actually supposed to be the bailiff, but I'm not even sure about that. So we'll have to look at that. So I guess I understand it was a good suggestion that you've made, but I'm afraid I don't know enough of an answer right now. So I'm going to send this up now.
Thank you.
All right, would you make a copy in the upstairs?
And then, Your Honor, can we be excused to go do some research on what you're talking about?
Please do.
Okay.
Please do.
Thank you.
Judge moments ago. Let's shift gears real quickly and talk about our good friend over at MyPillow, and that's, of course, Mike Lindell. If you missed the broadcast last night, we had the full interview of Mike Lindell and President Trump on our Rumble page, if I'm not mistaken. If you missed that, go check it out. You can also check it out on Frank Speech as well. Mike Lindell has been one of those patriots that has been out there from day one, really fighting for the American people, fighting for truth and justice, and making sure that our election integrity is in place. And so I encourage everybody right now to go over to mypillow.com. That's mypillow.com, and get a jump start on your holiday shopping. Of course, we've seen what the supply chain issues look like. We've seen the delays in shipping. I tried buying something the other day, and it said the ship date wasn't until like December 17th. That's going to be too late. But you can avoid all of that and not only help out a great guy like Mike Lindell over at MyPillow. So I encourage everybody to go over to mypillow.com, put that promo code RSBN at checkout, and yes, you will get up to 66% off your entire order. On a day like today, I kind of wish I had those some flannel sheets to wipe around me, as it's gotten a little colder than it was this morning. This is the weirdest weather up in this part of the country, these temperature swings. But go over to mypillow.com, and I've said this before, if you don't have an American flag, go buy one. You can go to mystore.com. They got plenty of items there. You can simply load up that shopping cart, put the promo code in, and see just how much you can save over at mypillow.com. That's mypillow.com. We certainly appreciate all of his support for our networking. And also keep up with what we're doing is go to rsbnetwork.com. That's rsbnetwork.com, and sign up for our newsletter. That's a great resource to stay in touch with all the things that we're doing right now. Simply put in your email address. We will shoot a newsletter to your inbox. We're not going to spam you. We're not going to send you a bunch of junk mail. We're going to send you articles, wonderful articles written by our tremendous writers here, staff writers, on topics that you care and love about. Our school system, the economy, immigration, of course, what's going on in our elections and in the court system here. So go over to rsbnetwork.com, sign up for our newsletter. You'll just click on there, put your email address in there. It's just that simple. And while you're there, also feel led to donate. You can do that as well, as we are partially viewer funded. We're viewer funded by people like you that make this little conservative outlet as big as it is today, and such a force as it is. Like, I can assure you that we were pretty much the dominant force yesterday in covering this case and getting the word out. So we certainly appreciate, because of you, we're able to share this message across the country. So thank you so much for your donations. That's rsbnetwork.com/donate if you feel led to give. Quick weather update here. We said earlier, we started out this morning, it's about 59 degrees and quite muggy in comparison to what it was yesterday. That has changed over the last couple of hours. The clouds, the clouds are still here. The wind has picked up a little bit, and guess what? Now it is spitting a little bit of rain on us today. There was a chance of showers throughout the morning hours, around a 40% chance. So it looks like we're seeing some of that now. Hopefully that will clear out of the way. Now, as far as when we can anticipate any type of verdict in this, is our guest right now. Right now the trial has paused as jurors are coming in and reviewing videos privately in the courtroom without public media in any kind of law enforcement around. So they're still looking at evidence on this, and you've got 5 counts that are against Kyle Rittenhouse here. Now, 2 of them were dismissed. I believe a curfew violation was dismissed, as there was a curfew at that time. Like many cities across the country, curfew was in place during the summer of 2020, as we saw a lot of looting and rioting going on. So there was a curfew in place. That charge had been dismissed. Also, possession of the firearm as well. He was 17 at the time of the possession, but the length of the barrel was one discussion that came up with all of this, as far as, did he have the right to carry that firearm on the streets that night. Now, if you're wondering why Kyle Rittenhouse was on the streets running around with that AR-15, he was asked by local businesses here in the Kenosha area to come up and I guess protect and stand guard of some businesses that were there. That's questionable. I mean, if from a parental standpoint, I'm not sure I would approve of my 17-year-old son grabbing a weapon and going out on the streets and potentially involving himself in some kind of dangerous situation. That is not up for discussion here. That's something that is much a side note, but it is something we should all think about. Was it safe for him into the first place? Is that his responsibility to do something like that? Is he at the age to consider himself knowledgeable and make enough some good judgment calls in situation, and that's something that parents need to address. And we talked about yesterday, one of the young ladies that talked to us and said one of the biggest problems she faced that we thought she faced in our community was the lack of fathers in the house and lack of leadership in the house. There's a lot of the two victims in this case, and the one that was injured. All three of them had criminal records, had criminal backgrounds, had served time for some real heinous crimes that they committed. Now, that's not justifying anything to what happened, but if you look at the amount of people sometimes that are involved in these marches, these rallies at night, the looting and the violence that took place, yes, there's a lot of good people that are out that just want their voices and their opinions to be heard in regards to what's going on. But you also have a lot of people that are very opportunistic as far as they know exactly what they're doing on the streets at 2 a.m. in the morning, running around, committing acts of crime. That's what they do, and that does not justify whatever happened, and the reason why they're doing it does not justify them breaking the law. It was interesting to hear yesterday just how many people would openly admit that they have involved themselves in some type of criminal activity. And I once again, if you're for the law, you're for the law, and you can't say I'm for the justice system and then turn around and break the law. On the other hand, we had a couple people yesterday that seemed very polite, very cordial to others, and then we saw some that weren't as cordial as they should be, as we all feel like your freedom of speech should be protected and honored here, and some of these people here feel quite opposite. Interesting scenario that we're at. We're at this medium that separates the courthouse and another house behind me. We've got a train coming by right now, just inches away from my cameraman. He's doing a great job sitting there. Kind of made me nervous there for a second, but it's a beautiful area here in Kenosha. So what you have today, and let's just kind of recap before we dip out of here, and we're going to check on the top of each hour. We'll drop back in and give you an update to what's happening outside, and of course recap anything that's going on inside the courthouse. The crowd, a little smaller than yesterday, I'd say, in comparison to how many people were here yesterday. A lot boisterous yesterday than it was right now. That could change as the day progresses. Will we get a verdict today? That's probably the number one question I'm being asked on social media. Your guess is as good as mine. This would be day 2. If they went all day today, that would be day 2 of deliberations. Now, talking security-wise, at the top of this hit, I talked about how security has been increased, not only for the prosecution and the defense, but also for the judge and the jury, as this is not a sequestered jury. They are allowed to leave. Now, the small community of Kenosha, that is one concern, that people could be targeted by certain groups and intimidated to give a certain verdict. Now, that is one aspect of security. The other aspect of security is that the governor here has deployed about 500 National Guardsmen to respond to any type of rioting or violence that might occur in regards to a decision here in this case. So those 500 National Guardsmen are about an hour and a half away from where we stand right now. So I was also told by a law enforcement agent yesterday that the protocol would be that the judge would say a verdict would come at X time in order to give those National Guardsmen plenty of time to get to this area and be able to at least have a presence and to be able to respond to whatever would happen. So whenever we do hear from the judge about a verdict that could come today, I would at least think it would be a 2 hour to 3 hour heads up before that verdict is given. to let the security team move in. That is just based upon the knowledge that I've gotten today. We're hearing a couple bullhorns. We talked about that earlier yesterday. You know, it was really quite quiet until some of these people come up and they just get on these bullhorns and they just keep circling the same message over and over and over again. I will say we had, I don't see her out here now. We had our first American flag. Think of what a novel concept to be waved out here today. Earlier, I don't see her here. So we have a few patriots here, a lot of people supporting Kyle Rittenhouse's right to protect himself. And they saw you've got the media involved, labeling this kind of a racial situation. You've got the mainstream media. A lot of them have already kind of prosecuted Kyle Rittenhouse to be guilty. Now think about this for a second. If you were Kyle Rittenhouse, where does your life go if you're found not guilty? You simply cannot Google this guy and not see all kinds of obviously negative articles about him, and not only just the news cases, but very subjective articles about him. So where do you go if you're Kyle Rittenhouse after this trial? And that's one of the things we were talking about offline. In this hyper connected world that we live in, I'm not quite sure what you do, where you go, because your name has been tarnished. Your name has been smeared by many in the media and in society. So not quite sure what happens at that point. But we're out here. We'll be live on top of each hour, giving you an idea of what it looks like in here and updating you on anything in the court and inside the courtroom. I also want to encourage everybody to let us know where you're watching us from. As we jump off here and we're able to get into the chat rooms and read some of the comments, I'll be commenting as well. Just often curious where our viewers come from. Of course, we love each and every one of you. If it wasn't for our viewers, we wouldn't be here doing this right now. So we certainly appreciate your feedback and all of this. And also share our streams if you could. Click on the links on whatever platform you're watching us and hit share and put it up on Facebook, tweet it out on Twitter, and push it out there. And let's see if we can get as many people watching this today as possible. A reminder, follow us on all of our social media platforms across Facebook, Instagram, Twitter. Of course, watch us on Rumble, download that as well. And Getter. Big shout out to Getter and Jason Miller and his team. My goodness, absolutely exploding yesterday on the views coming out of Kenosha. So big shout out to those guys, as they have really vamped, given that social media platform a facelift in the last week or so. I mean, your videos are just the high resolution on your videos, and it just looks great. So shout out to those guys for Getter for really upping their game on that. You can follow me as well on social media at Brian Glenn on Twitter, Facebook, Instagram. Follow me. Look for the blue certified check mark on Facebook to make sure you got the right one. There's a couple of those guys floating out there. So anyway, I'll step aside. We've got, once again, people gathered out in front. We will dip back in at the top of the 12 o'clock hour Central Time here in Kenosha, Wisconsin. Until next time, we'll see you guys back here in a few.
Mr. President, President of Belarus. Mr. President. Mr. President of Ireland.
And we need to defeat this bill. Now, somebody that's going to talk about it who's really been leading the charge, our Budget Committee lead Republican, Jason Smith.
Thank you, Whip Scalise. You know, for months, the Democrats have been obsessed with passing a reckless tax and spending piece of legislation while ignoring the needs of working class Americans. Working class Americans right now are concerned of how they will put food on their table, clothes on their backs, and gasoline in their cars. And just since Joe Biden has become president of the United States, inflation has risen by more than 7%. This bill that is before us, this tax and spending bill, is marked with numerous budget gimmicks and shell games to hide the true cost of the spending. Even independent analysis from numerous economists, even the New York Times, has predicted that this bill is more than double of what the Democrats are saying. Right now, we are facing inflation at the highest amount in 40 years, and their solution is to spend more money. That is not the solution for America. That is not the solution for real Americans who we represent. The CBO has scored roughly 12% of this legislation.
In which you, because it was actually a video of the incident itself, not of a statement. So Franklin is about a defendant's statement, Anderson's about the statement of a child. Here we're talking not about statements, but a video of the actual incident. And that was, you sent the video, I think it was an armed robbery, back to the jury room. It was appealed. There's a per curiam unpublished opinion.
Can you cite a case that the judge actually remembers?
That what?
I remember. This was on 75th Street. I hold up at the I don't know, it's about 43rd Avenue and 75th Street, and there was a video of the incident itself. And go ahead. I'll take the fine. It's $50.
I hope he's ready to take it too.
I don't know. You know, this is what I mean about insulting the jury. That's what we're doing. The big thing about breaking the tape, that's from the original Maurice Franklin case. I talked about it a few days ago. I tried that case right here in this courtroom. I was a district attorney, and he was on trial for murder, and he had a very small role in the armed robbery in which a man was killed, and so he was charged as part of the crime, and he had a very non-knowledgeable and stubborn attorney, and insisted on taking the case to trial without really, for whatever reasons. And the law was clear. It was a premeditated murder by a 15-year-old boy. And Mr. Franklin was, I think, 18, and he never even entered the building. He was a lookout. And the defense attorney stood right down there and said, the intent does not transfer from one person to another. And then the judge correctly read the instruction. It's called transferred intent, and he's guilty of any act which is a natural, probable, and usual consequence of the armed robbery. And that concluded the murder. And so Mr. Franklin was convicted of first-degree murder. Judge Morton, who was a wonderful man, who had a heart of gold, and who knew the law, granted judgment and sentenced him to life imprisonment, and commented that he hoped the case got reversed. And it was reversed for a different reason. But they discussed that statement that you're talking about, a tape-recorded statement. This was in 1974, as I recollect, right on the heels of Watergate. Rosemary Woods erased 14 minutes of President Nixon's behavior. And there was he lost his job. And so this was a big deal. And so the Supreme Court mentioned about the breakage of the tape. That's not an issue, you're correct. They also talk about exaggerating some aspect of the evidence. The defense, the state, I should say, is totally correct that the incident on 75th Street that happened more recently, what was the name of it? Flint. I admitted that because I said, no, that those rules don't apply because this is actually an image. These are images of the event occurring as opposed to a statement of the accused or a statement of a witness, which were the case in the Franklin and Anderson cases. And so I do feel that those rules are not, the rules to be derived from Anderson are not strictly applicable to the to footage from the actual event which is claimed to have been criminal. So it's not just that one case, there have been other cases that I've admitted these videos and let the jury play them. I complain about the case of, well, I don't remember the man's name, but he was convicted of attempted murder of a police officer. Well, actually, I think of reckless endangerment or something, but because of video footage that they had to come down here and watch on a tiny computer, and we had to bring them down 3 at a time because we could only let them see it one time. I think that's so outrageous. But, you know, I have to be aware. You want me to kind of just let them have what they gather, what you say, although actually most of the time your office has come in here and told me, no, Judge, don't risk our case. So don't send this. What do you want me to do? What do you want me to do? Tell me.
Judge, I do not believe Anderson applies directly. I believe that because it is of all these requests are of the incident themselves, or incidents themselves, that I believe the jury should be able to watch them as they see fit, watch them, pausing them, rewatching them, watching them in any way they see fit, in any configuration they see fit. I believe that the Franklin and Anderson cases, I understand how someone's statement, a videotape statement, could be overemphasized. I do not see how videotapes of an incident could be overemphasized or looked at too much. And really that's what this whole trial has been. While there's been lots of testimony, almost everything testified to is on video. So to me, I believe it is clear that given that it's a videotape of the incident, they should be able to view it as they see fit. Now, Anderson, again, of a statement, says it should be in open court. That certainly can be done. The jury may feel uncomfortable, obviously. So I think if the court makes specific findings as to why it's appropriate in this case to send it back, we could send it, or actually what I would propose is making the courtroom the jury room, clearing out the courtroom, checking for any devices that would be recording the deliberations. We can either give them all the exhibits and instruct them to only watch the numbers that we agree on or that are allowed, or we can put them on a separate drive, the exhibits that they've requested or that they'll be allowed to see, and they can essentially have access to all the screens here and they can play it and do it as they see fit. Now, with this distinction of it being the incident itself, if the court makes findings of why it's appropriate, the state believes that it will survive any scrutiny on that issue if there is any kind of guilty verdict.
Well, you're suggesting an abandonment of the insulting precedent of the last hundreds of years, that the jury might overemphasize some aspect of the exhibit. He says it should be played only once if it's played at all. And you say play it as much as you want, which my intellect tells me is the best way, because as I talked about the Tsarnaev case, that's how it got solved. And it seems to me this is a pursuit of truth, and you should take the course that you think will lead you there. And if the jury thinks they want to look at it 80 times and they want to talk about it and criticize each other for their respective views of it, I think they should be allowed to do so without interference on our part. That has not been the law in this country, which, in my estimation, treats jurors very poorly. And so I don't know. Your office, this is the first for me that your office is agreeable to this, but that doesn't mean you can't do it, because you can.
And usually, the only time I've ever encountered this issue, I can't speak to everyone that's been in my office the last few years, the only time I've ever encountered this issue with you or any judge, I believe, is because it's a statement. And the video of the incident is different. So, and what the court must weigh is whether the exhibit will aid the jury in proper consideration of the case, which you and I at least agree, whether a party will be unduly prejudiced by submission of the exhibit, they've already been submitted, and then improper use. I understand how, especially a statement of a child or a statement of a defendant being reviewed over and over and stopped and rewound, how that could be an issue. But of an actual incident like this, which is what this whole trial has been, is showing videos of the incident. And I think it is fair to this jury and fair to the process and frankly fair to the defendant if they're able to see the videos as they see fit. So we can either give them, if the court adopts this, we can give them a drive with the acceptable exhibits. They can play them. They could have access to the court technology if everyone is kicked out, and it can continue as that. I don't know if the court can allow that with its calendar, but
this is more important than anything I've got on the calendar.
The state's position is that Anderson is very strictly relevant only to a statement of a witness or defendant.
By the way, what about, I now have had the chance during the break to read the defendant's motion for dismissal.
Yes.
And there are allegations made there about the material that was provided to them.
Yes.
Certainly if I follow through on what you wanted, I think I warned the other day because I was queasy, very queasy about this particular exhibit from the drone. And we exchanged a lot of emails over the weekend about it. And I think I warned you the other day that you're putting an awful lot of emphasis on this. And if it turns out that it's not technologically sound, I referred to it as the situation as a house of cards. This is just more weight on that. If I now allow them to review it without restriction as to the number of times,
Judge,
you're comfortable with that?
we are. Now, if I can respond at least to that portion of the motion to dismiss, it's factually inaccurate. So let me go back to the first Friday of trial. Mr. Lukowski was testifying. In the middle of his testimony, I got a notification that there was someone at our office who was refusing to give his name with a drone video. This drone video was shown on Fox News a couple days after the incident. It apparently was on the internet briefly and then taken down. The defendant's first attorney, Mr. Pierce, appeared on the Tucker Carlson show and discussed the video and seemingly brought the video. We've been told since then by the person who took the footage that they've sold the video to Fox News. Now, we've had a poor quality of this video the entire time. It's actually in Exhibit 41, which the defense submitted. On Friday, the individual who took the footage, who had been unable to find, came and airdropped the footage to Detective Howard. Airdropping is a way that it just goes from phone to phone. It doesn't go through text messages or email. It has to be iPhone to iPhone. So in the middle of Mr. Lukowski's testimony, I asked Mr. Howard to go, and our investigator, to go speak with this individual and see what he had. I suspected it was this video from the Tucker Carlson show. It was. Detective Howard got a airdropped copy. He brought it into court. As soon as the next break happened, which I believe was just minutes after he arrived, as soon as the next break occurred, which I believe was just minutes after Detective Howard arrived, I took all 3 defense attorneys in the back to discuss a couple of issues which are not relevant, and I also indicated that we now had a much better quality drone video. Detective Howard asked them how they would like to receive it. Ms. Wisco asked that it be emailed to her. He emailed her the file. Now, somewhere along the lines, whether it was, it appears the issue is, I believe Ms. Wisco could not have an airdrop because she has an Android phone. Going from an iPhone to an Android, it appears somehow compressed the file.
I have an Android phone too.
We did not know that this would occur. If I knew how to compress files and knew all this technology things, I'd have a much better job. So this file was given to us. We gave what we fully believed was the full file to Ms. Wisco. It was admitted to evidence. It was the authenticity was stipulated to. It came in without objection. We've heard many times this trial how there was no objection. It was an exhibit for 4 days and played and shown to the jury and on the screen for 4 days. And then on Friday is when I think we all discovered that something had happened to Ms. Wisco's file. She played it on the big screen. It clearly looked different than the copy we all had. I believe we offered to airdrop it to the other attorneys, and I think it was declined because they didn't know how to use airdrop. And then we got her the full copy. We cannot be held responsible for the software on Ms. Wisco's phone. We didn't compress anything. We didn't change anything. That would have been something that happened in the transfer that we had no knowledge of. We of course did not mean to give them a different copy, and until Friday when Ms. Wisco played it and it looked different than what we've been looking at, we had no idea it was any different. And then when requested, I gave her, so what I did is I took an email from Detective Howard. He emailed me the file. It was not compressed. I don't know, probably because it's Apple to Apple, or I was using Gmail at the time. It was the full, as far as we know, the only copy of the video we were ever given, the only copy that's ever been had, and then I put it on a thumb drive to give to the State Crime Lab. So I cannot explain why Ms. Wisco's file had been compressed. That is not something that we can be held accountable for. We didn't know it. We don't, and if Ms. Wisco knew it, it wasn't brought up until Friday. Now, there was some dispute Friday about there being different copies. There was no different copy. The software on Ms. Wisco's phone, or whatever software she used to view it, compressed the file. The only compressed file is the one Ms. Wisco has. All the ones that we have seen, and we did not alter the file. None of us know how to alter the file. None of us know how to compress the file. We wouldn't have had time to do so. You can probably go back on the footage and see when Mr. Howard, Detective Howard brings it in, and while Mr. Lukowski's being questioned, we're looking at it to see if it's the drone footage that apparently the defendant's first attorney had or was aware of. And I understand he has different attorneys now, but this is still the defendant's attorney at the time knew of this 3 days after the incident and was talking about it on national television. So to somehow now accuse us of compressing a file and somehow being able to do this technical wizardry to somehow sabotage the defense is preposterous. The defense saw this video and thought highly enough of it that they went and bought a large television that is now being used in court because they wanted to show it. And now all of a sudden to come back and say, well, we had a bad copy, they could have checked, they could have asked for a thumb drive, they could have asked for whatever. As far as we knew until we had this hearing on Friday, everyone had the exact same copy. And that Ms. Wisco's phone compressed it is not our problem. It's not, we're not responsible for that.
She can go to her phone.
If I may.
Well, no, one at a time. One at a time. Well, why don't you start, Ms. Wisco?
Can you talk into a microphone? Yes. On November 5th, 2021, I received at 10:33 a.m. an email from Detective Martin Howard with one video file attached. It was a 4 millibyte video that was titled IMG_0159.MOV. I have never looked at that video on my cell phone. As soon as I received that video via email, I downloaded it to this laptop, which is the evidentiary laptop we've been using through the duration of this trial.
What manufacturer is that?
This is a Lenovo.
Okay, good.
And I relabeled it after it had been brought into evidence by the state as Exhibit 73 because it was Exhibit 73 for ease for bringing it up, showing it to the jury. After we found out in Friday that there was this discrepancy after the videos being shown, and for the record, we did not buy that TV because of this drone video. We actually brought it in for John Black's slowed down testimony. That was the reason we brought this TV in. However, when we were in court, I played the Exhibit 73 on my computer because the state's computer wasn't here. 88 Krause was the one who brought up the fact this isn't the good quality video. We didn't realize until playing them side by side, mine and then the state's, that there was any difference in quality. That was Friday. After Friday happened, I emailed both Binger and 88 Krause, and I asked for an exact forensic copy of what they had given to the state crime lab. 88 Krause responded back to me, forwarded me the email he's talking about to Detective Howard, and that also contained one file named as IMG_0159.MOV that was a 4 megabyte file. Simultaneously, 88 Binger had been in contact with me, told me I could come pick up the file from a flash drive. I drove here, I had him take me inside, and I confirmed that this file that he said was directly provided to the state crime lab was an 11 megabyte file, not 4. So the information contained in the flash drive was over double the size, almost 3 times the size as to what was emailed to me. When 88 Krause followed up to me with that email, forwarding me his email from Detective Howard, it was the same 4 millibyte file that I had gotten previously.
So clearly Attorney Wisco's email is compressing these files. That's not our responsibility. Oh, I didn't write Outlook software.
You know what?
I forwarded
But wait a minute, I don't know if she had finished.
No. Every other piece of evidence from the state crime lab in this situation has been provided to us via Dropbox. Dropbox provides an exact forensic copy of what they have. The file title name in this situation should have been exactly the same as the one provided to the state if it was the exact same copy. The file name was nowhere near similar. The one that was provided to the state's crime lab that Attorney Binger gave me a copy of on Saturday had a very long, convoluted title that involves lots of letters and numbers that are the type that are usually associated with files taken from a drone because they indicate a lot of different information like the location of the drone and the time. The file I received originally on Friday the 5th was not labeled that same and was not the same file amount. There's no way that what 88 Krause is saying is true because the file name would not have changed if my computer was compressing anything. It was a different file that we were provided from what was provided to the state, at least for what Attorney Binger gave me on Saturday. They're completely different.
I think we're confusing the issue here. The work product of the State Crime Lab is sent via Dropbox. That's how they've submitted all the videos that they worked on and the photos they worked on. The email from my personal Gmail account is the file that went to the State Crime Lab. I was told to bring it to the State Crime Lab. I was already home on Saturday. I did not have access to anything but my computer. I had Detective Howard email it to me, and I put it on a thumb drive at home, and I took it to the crime lab. I don't know if Mr. Binger somehow retitled it, but the image I gave the crime lab is on my phone as the title that she indicated. That was the one that went to the crime lab, and I will testify as an officer of the court. I take offense that what I'm saying is untrue. Clearly,
well, obviously we're going to have to take this testimony under oath, and we're going to have to get somebody to explain all this, who has some competence, which...
If you look at the report from the State Crime Lab, they indicate the originating file that they received was the one with the expanded title that we did not receive until Saturday. If it had been the same file as 88 Krause says it is, why wasn't that labeled on their receipt as being IMG 059 or 159?
Mr.
If
Krause?
that is the exact same thing, then that does not add up.
Mr. Krause?
Why did he include in his report a different title?
I'm looking at the email. It is image0159.mov. When it's downloaded to computer, perhaps it has a different title. On my phone and on my Gmail, that is the image. I'm watching the video right now. This is the precise one that was given to the State Crime Lab. I had no other access. At this point, the first time this was ever put on any kind of hard drive is when I did it Saturday at my home. And I'll do a little experiment here. I'll save it to my computer and see if the title changes. But
we're going to do this. Pardon me?
I accidentally saved it 3 times because I was trying to re-download it multiple times, and it all saved it as IMG 0159.
Okay. Well, you know what? We can't resolve this now because this is going to require expert testimony from people, and we're going to have to take testimony under oath as what the facts are, and so that I'll reiterate my comment, which started this discussion, which was that given the cloudy picture about this particular exhibit. Yeah, this is a high-risk strategy for the state. I was queasy about this from the beginning, and I'm only queasier about it now.
Judge, what we propose is to show the jury the exhibits. I'm really not concerned about the image. As I've said multiple times, I believe much too much has been made of this image. Mr. Binger didn't even mention it in his closing. We didn't show it in either our closing or rebuttal. The other evidence was admitted without objection with a stipulation to authenticity, and I believe it should be played. It's already been played for the jury, and they should be brought down, and we can put all the other exhibits on a thumb drive outside of 160, what is it? Outside of exhibit 155, which is the the image that the court is received over objection, but the other exhibits were not objected to. And again, the defense, although a prior attorney, had access to this video 3 days after the incident. So to now claim that they're somehow prejudiced is preposterous. I understand it's previous counsel, but it is still the defendant's attorney. He was charged with this crime, and if Attorney Pierce did not turn something over that he had and that he seemingly brought to the Tucker Carlson show, that also is not our responsibility.
Your Honor, can I briefly respond to that?
Yes, sir. Yes, sir.
Mr. Pierce was my client's attorney. As Mr. Kraus said, Tucker Carlson purchased that video. That video is very different from the video that was delivered here in quality, color, there. We stipulated to the video based upon what they gave us. We didn't see it as anything different. We were given...
I want to stop you now. Okay. Because why do you say that the one that Mr. Carlson bought, Tucker Carlson bought, is different from...
It's black and white.
Ah, that was, okay. Go ahead.
And we stipulated to that video when we looked at our copy because it didn't add anything except color. We didn't have the quality. And that's where this whole problem starts. And we weren't aware of the quality until after the evidence had closed on Friday, when we were here and it was plugged in as Ms. Wisco was saying. That's when we found out there was a problem, what had been given to us versus what they had. That's when the whole problem comes up. So that's as to that video. The other one, and I'll just say it because it's going to be an issue, FBI aerial with all POI'd marked. That, when we're going over this list, it's come to my attention. I played that for the jury. It never got marked or moved in, even though it's been played.
Are you kidding me?
I am not kidding you,
Can we
Judge.
put it in evidence now?
That's what I think would be the proper way to do it.
If the defense agrees that all the drone videos go back, we will agree that that should be
Can I
marked
run a
in
compromise?
evidence.
This isn't, let's make a deal here.
Well, they did not mark the evidence. They did not move it.
But it was played to the jury.
Yes, and not marked or moved.
I thought it was part of the hard drive because everything was going in.
And I thought we gave them a full and complete copy of the video. So.
Well, I'm going to reopen the evidence and admit what they saw. Give it the next sequential number.
Well,
how can I not give it to them? You tell me.
I mean, then I would ask that evidence that's been admitted also go to the jury, that has been legally admitted in front of the jury, and follow the proper procedure.
Let's take one thing at a time.
Your Honor, just for the record as well, there was an additional difference that we found in the metadata between the two videos, is that if you look at the metadata from the file that we received from the state, is their create date is 11/5/2021 at 15:10:31. If you look at our video that we were provided, the metadata, the create time is 21 minutes and 19 seconds later.
Judge, we're looking at the Tucker Carlson interview with Attorney Pierce. It is not black and white, it is color, and it actually does seem to be high definition like this video. We're watching, it's online, you can watch it.
The one I have is black and white.
Mr. Rittenhouse's attorney has seen the real version.
What about that? If his prior attorney, he's got it.
I don't know. They said that Tucker Carlson bought it. And that's what goes to this whole thing, this urban air. We sent out an investigator to interview the owner of Urban Air to try and get this video. And I can get the report, I don't have it with me. And the individual lives out in the Lake Geneva area, and he lied to our investigators and said, we are mistaken that the drone permit wasn't for this video. And now it's come from his company. He shut down his company 17 days after this video was released. We've tried to get this video, and then it shows up on the Friday after the trial has started. And it's dropped off by his employee, not the person who we interviewed who owned the company.
I don't know who was interviewed. I believe that is the owner Mr. Beeman? Oh.
I'm shaking my head no. I answered no to Mr. Russell's question. I apologize.
Well, this is number 5, and they say, please prepare. And then it lists these things, and then it says, we will request when ready, and they haven't followed up. So I'm playing short. Maybe the ball won't come to me.
So, well, if we're moving on, at least for the moment, let's go to number 4.
Yeah.
So it seems that the request, it says view video, but I believe it's actually, 3 videos.
I did not hear you, sir.
It asks for a video, but I believe they're actually asking for 3 videos, and I think we agree on this, that it asks view video starting with Mr. Grosskreuz's interview with Mr. Rittenhouse. That is Exhibit 3. It's also duplicated as Exhibit 57. That is the live stream that Mr. Grosskreutz took that night. That does not actually depict the second incident. It does, you can hear the shots, but then it asks to 10 seconds after Mr. Grosskreutz shooting. I believe that's what's referred to as the BG on the scene video, which is number 5. And then it indicates in regular and slow motion. The only slow motion of that incident is the BG on the scene video, and that was the one that Dr. Black created and played. That was moved and admitted. It does not formally have a number because it's on a drive. We do not object to it being given a number and sent back, or well, played however the court deems appropriate. So, so we would ask that. So I believe there's 3 exhibits they're requesting. The state does not object to them having access. However, it is deemed appropriate to those exhibits.
All right. So, and that's by agreement. And then the question is where and what restrictions will be put on their use of those videos.
The state's position is that they should be given the exhibits or told what numbers they are. The courtroom should be cleared. They should watch them on the monitors they've been watching the whole case on. And that can be set up, and then everyone can leave and they can discuss it. Now, it says...
all by themselves or...
by themselves.
Okay.
Just as they
I assume that somebody has got the technical ability to trigger playing of the videos.
That's a fairly simple process. They can be given a computer with you just plug it into the side and then they can just press the thing. If there's...
It doesn't have other matter on it?
We have, I believe our computer, if it doesn't have anything else in this case, it may have like Microsoft Word or something on it, but there's no other evidence of this case on it. It's not my computer. It would be we have some standalone laptops to do this type of thing.
What's the defense position?
Judge, we were talking about it, and the question that I have, and I don't have an answer because it wasn't in any of these cases, is there any right, if we're doing it in court, is there any right for Mr. Rittenhouse to be present?
I don't think so, any more than if they had paper exhibits and they were discussing them. And certainly the defendant can't be in the room while they're talking about them.
Well, I agree with that.
Why is the video different?
Well, if you clear the room and say this is now the jury deliberation room, which is what they've asked.
No. I want to go back a step.
Okay.
Supposing I said, well, let's just get a computer that has nothing else on it, or that is everybody feels it's sufficiently sanitary, and let's put these exhibits on a flash drive or download them onto the computer, whatever, and then send that upstairs. Let them do it just like they would if they were paper exhibits, and they can play it and discuss it as much as they want. Now, I'm talking right now only about question number 4, because there's other issues with respect to question number 5, and fortunately they're not here yet because they haven't requested it. But this would be a departure from the Anderson case for sure. That would not be incompatible with what I did in the Flint case. Flint. Who's okay with that?
I'm sorry?
Who's okay with that?
We are okay with that.
Is, based on what you said, so we're not waiving anything on 5.
You're not waiving anything on 5.
Then that's okay for 4.
Okay, now we just need to get a clean computer. And you say you have some available, Mr. Krause?
This
One of those?
I have to look at it, but it can be clean quickly.
Look at it. Well, I'm going to go and do something else. I'm not going to go. I'm going to stay. I'm going to stay and do something else. And I'll let you fellas try to work this up. And
at this point, Your Honor, they have not requested what we're fighting about.
They have not requested?
At this point, they have not requested what we're fighting about.
You are correct.
Okay.
Good afternoon, everyone. It is an official and personal honor to welcome the Prime Minister to the capital of the United States once again. Once again, for us to restate the friendship that exists between our two countries, and for me to salute the Prime Minister on his leadership role in the world on addressing the climate crisis, addressing COVID, and so many other issues. In our two countries' relationship, the issue of security has been one that we have shared and been a strong voice globally together. The issue of the economy of our two countries in this hemisphere is an important role for both of our countries. And the issue of governance and values. So again, it is always after hundreds of years of friendship, official friendship more than 150 years between our two countries, longer between our two peoples. Again, it is an honor to welcome the Prime Minister of Canada, Justin Trudeau.
Thank you, Madam Speaker. Thank you, Nancy, for your leadership and your welcome here today. What a pleasure to be back here at the U.S. Capitol to talk about the many things that bind us together as friends and allies, whether it's finishing the fight against COVID, where we have stood side by side through these very difficult times, but also engaging with the world to make sure that we end this pandemic everywhere so we can end it in all of our countries. Also moving forward on the fight against climate change, which remains an extraordinarily urgent crisis that we need to continue to step up more and more. I was very, very pleased to see all the leadership that the United States has brought to bear, not just at COP in Glasgow, but in the months leading up to it and in the months and years to come. And of course, we have to talk about the global economic recovery and how we're going to continue to deepen our partnership and cooperation to create good middle-class jobs on both sides of the border and indeed continue prosperity. A lot of concern around supply chains and making sure we're fully benefiting from the benefits of the new NAFTA, the USMCA, and the work that we can do together on a broad range of things, from electric vehicles to critical minerals to a lot of things to work on, so I'm really looking forward to it. Toujours un grand plaisir d'être ici avec la Speaker Pelosi pour parler des enjeux, que ce soit le climat, que ce soit la COVID, que ce soit les chaînes d'approvisionnement et notre économie. Nous avons beaucoup de travail à faire et je suis très content d'être ici. Merci beaucoup tout le monde.
Be here on multiple occasions. What you're seeing here is simple. You know this, but I'll just say this, it's a little more personal. This is jaw-dropping without precedent. You've never seen 6 containers stacked high. You've never seen sites like you're seeing here. And as John said, I know it's hard for folks to acknowledge, but what we're seeing here is success in this respect. And I want to just make sure that this is part of our conversation. And that's the productivity of the men and women that are working these ports, that are doing unprecedented amount of work at unprecedented speed and scale. This is not because they're not doing an extraordinary job. This is because the extraordinary demand. So we have record-breaking throughput, unprecedented in this state, this nation's history, because of their hard work and their commitment and resolve. They're not dialing it in. They're not phoning it in. They're not calling in sick. They're not just pointing fingers. They're the guys and gals on the ground getting stuff done. And so I'd be remiss if I didn't conclude with that punctuation point that seems to have been lost in this debate which is so often politicized in this country around who's to blame as opposed to what the hell to do. And so that's the spirit that brings us here today, to focus on today and tomorrow and the future with gratitude and humility of the challenges to be done. We're all here to answer any questions.
So, Governor, a lot of people see this through the prism of the highest inflation rate in over 30 years. Yes, you've got infrastructure investment through the legislation signed 48 hours ago, but when can this be solved? Are you looking at the second communication said not till perhaps the second quarter of next year when the supply chain issues be ironed out even at that point?
Yeah, look, if I had a crystal ball and I was the international leader, I could be able to give you a better viewpoint because this reality exists and persists in all parts of the globe. This is by no stretch of the imagination unique to the United States of America, nor is it unique to Southern California. Generally, these issues persist in other ports, including Savannah, all across our country. That said, 32%, I hope that wasn't lost, Mayor Garcetti, what he said, we have seen progress, about a third reduction in the dwell time of containers sitting here waiting to be picked up on a 6 or 9 day rotation. So there's real progress that demonstrably has been made in moving things forward. And I want to acknowledge that there's just a lot more work to be done, and that's self-evident as it relates to what you see behind me. That said, we're seeing more sweeper ships, which is just a fancy way of saying ships that are coming out here for the sole purpose of getting empty containers out of these locations, getting them back on ships and getting back into Asia. We're seeing an increase in those ships. We're seeing an increase in cooperation with the carriers to move some of this stress to Northern California. We have commitments from 2 carriers to go into Oakland, a third in January to start to relieve some of the stress here at the ports. So there's progress being made in terms of the macro, in terms of global pressure of a pandemic-induced recession, and then a recovery that's exceeding in many respects expectation of even the most optimistic. Those supply chains will be tested in historic terms, and that will have to work itself out. You guys can hear better. The question was, of the $17 billion that's been identified through the infrastructure bill, how much do we expect to get in California, or how much would we like to get? We'd like to get all $17 billion. That's the first answer. Number 2, we're not naive. And by the way, I say that with some consideration. This is, you know, for those of you in the newsroom that are looking for an additional side story on the ports issue, look at how much money the Port of Savannah received over the course of the last few decades, and how little money we received here in LA and Long Beach, despite our dominance. And in many respects, you know, that's on us. There were directed appropriations over the course of the last number of decades that didn't come out here. It's not a cheap shot. It's not an indictment of anyone behind me. It just is
saved directly to the desktop of this computer. They need to be played through the VLC.
No, but there might be someone like me up there who wouldn't.
It's the only, I believe that Windows Media Player is the default. However, if you try and play them through that, nothing comes up. Sure, we can reset the default.
Okay, so we're all on board with that. Mr. Rittenhouse, you know what's happening here?
Yes, Your Honor.
Any question about it at all?
No, Your Honor.
Any problem with this?
No, Your Honor.
Okay.
Judge, while Attorney Wisco is preparing the computer, during this little break, we've done some more looking, and in terms of the drone video, I don't want to re-argue it, but I just want to state what happened. When Detective Howard obtained the video, he airdropped it to my phone, which is a lossless type procedure, or at least it didn't change anything. At some point, I emailed it to myself, which did not change anything. It has the file name, the long file name. I did ask Detective Howard to email it to me as well. Then it had the IMG file name that Attorney Wisco received. So somehow in this Detective Howard transmitting it to everyone, if it was emailed, it was compressed. If he airdropped it, it was complete. And that was not known by anyone until a few days ago on Friday.
Well, it depends. This may pass. They haven't asked for it yet. They wanted us to be ready, and of course we're not. But let's take a step at a time. And I just heard their bell ring, so perhaps they have something more of interest to us.
So, Judge, we've been talking. If they do come back with question number 5 or whatever it is, whatever. You have talked about in great detail and length, and it's completely appropriate, the transparency of wanting this to be a fair trial and everything else. And I'm finding that difficult in that one of the linchpins of the state's case was information. Go ahead.
I'm just going to interrupt you long enough to have the material that we've agreed to go up. So if that's ready, Ms. Wisco, we'll have the bailiff take it up. They're ready for the video. I don't know what that means. But let's send up what number 4, and then I will hear the rest of what you have to say about number 5. So is that ready to go up?
Yes, I'm having problems with setting it as the default because of the way that I sanitized the computer just now. So if we can go up with the note saying must play.
Send the note up. Have the DA look at it and make sure it's okay with them.
If you could make sure they plug the power cord in because the battery is low. It says must play all videos through VLC Media Player.
All right. Okay. Question 4, it's coming up. Yeah, go ahead.
If you could please keep it open though, so then they don't have to log in.
Yeah.
Thank you.
Excuse me. It's no longer allergies. It's a cold. But go ahead. Yeah, there's no restriction on their use.
So, Your Honor, we were talking during the break, and the reality of it is one of the main portions of the video, the thing that you watched, however many times you watched it, right, on a video that we had the video, not the clarity and not the quality. I think that's been conceded that we didn't have that. We would have done this case in a little bit different manner if that was the situation, where we didn't have specific, and I want to say we didn't have the evidence because I don't think that's a fair way to say it, but we didn't have the quality of evidence that the state had until the case had been closed. On Friday, the parties had rested, and we were going to open our closings on Monday. We've talked to Mr. Rittenhouse, and I'm going to be asking the court for a mistrial based upon the fact that if we're really trying to get to the heart of it, we've watched the video, I can tell you what we think, but it doesn't matter what we think because we don't get to present that to the jury anymore. And I think if we're going to try to do this in a way that is free from anybody hiding anything, anybody not having the same evidence as everybody else has, where it is clearly a level, fair playing field, we have to ask for this, and I'm asking for it. We understand that it's going to be without prejudice. We understand that the state can redo this case if the court grants it. We understand they will do it again. But then I think we will all have the same information, the same quality of videos, and I think that is required in a case like this where he's looking at a life sentence, potentially without parole if he's convicted. And to not get that until the evidence has already been closed, that doesn't strike me as fair. So for those reasons, I'm making that request.
All right, I'm not going to invite the state to respond yet because the jury has not requested to see number 5, and it'll still have to be addressed because the jury saw it here in the courtroom. But
I'm sorry, Judge, but if I understand Attorney Trofsky's request, this is a motion regardless of what the jury is requesting.
I think we're making that request because it's been shown, it's been pointed out, and in fact, we didn't have access. And I'm at this point, I don't think me pointing fingers and doing that is going to be the end-all, be-all. I think what it is I can tell you, and I think the state can tell you, we got a compressed version, which was not of the quality that they had. We learned that Friday, after the evidence had been closed. We learned that when we tried to play the video for Your Honor, and the state asked that their AV person be brought over to play their video, which was a higher quality. If this is a disorderly conduct or something, I get it. But we're talking about a potential life sentence here. So I'm making that request.
And again, I'm going to say that it has to be addressed if there's a guilty verdict on any degree. That count, well, even perhaps on the others too. I don't know. It'll all depend on a number of factors. Then the motion will have to be addressed, but it doesn't seem to have the urgency right now until the jury, if and when the jury asks for number 5. That doesn't change the fact that they're making the motion, or that it could affect the case as a whole. But I'm not going to invite your response now until I know whether the jury wants number 5. Does that make sense? If it doesn't make sense, tell me. He was told that they were ready for everything. So, that you have the state's response.
Response invited?
Yeah.
The defendant's first attorney, after he was charged with this case, appeared on an interview, appeared alongside the high-definition version of this footage. I understand he's gone through other attorneys since then, but the defendant himself would have been aware of it. His legal team would have been aware of it. Obviously, both sides have attempted to get it, and we were not able to do so.
What do you mean you couldn't? If you know Tucker Carlson's got it, you could have subpoenaed it, no?
We didn't know that until, I think, today.
No, we knew it.
What did you think it was?
We knew it was aired on his show. We didn't know that Fox News apparently purchased and has possession of it.
Okay. Did you inquire?
We tried to find Brennan.
We tried to find the person who took the footage and who ended up being the person who came to our office with it.
Well, I interrupted Go ahead.
So this is not a video that was in possession of the state in any way, shape, or form. It was out there in the, I guess, on the internet and in the world in that regard. And I think we're focusing on too heavily on, I guess, a technological glitch, and less on and we should be focusing that this exhibit was played. The jury is asking to see exhibits that they have seen and that the defense saw when they were played in court. What's on my phone or my laptop or the defense's phone or laptop is of no matter. What matters is the exhibit. And that exhibit was played. It was not objected to. The authenticity was stipulated to. And the defense, I understand they didn't realize it till Friday, watched this exhibit. They watched it on a television set a few feet from them. They could have watched it on the monitors here. That is what matters. That is what the jury sees. That is what they have seen. That they want to see it again is not prejudicial. It's not prejudicial in any way that the defense had a compressed version now. Obviously they had seen or had a full version at some point, possibly prior to Attorney Richards becoming the primary attorney. But that is not the fault of the state. And the fact that that some technology compressed this file without anyone's knowledge until Friday is not the responsibility of the state. And Defense Exhibit 41 has this video in it. So to pretend that somehow they're surprised or they didn't know about this video, they've tried to find it just as we did. We found it and there was a technological glitch. Or not a glitch, but I guess it worked in a way that is designed that we were not aware of. And Exhibit 41 not only has the drone video in it, which is the defense exhibit, it also has a circle around someone pointing the gun. As I said in my rebuttal, this did not seem to be a great issue until the defendant testified otherwise on the stand. And now all of a sudden, the defense is calling into question technology and not wanting videos in, and it's all to protect their client. And I understand that is their job. I'm not criticizing them for this, but their client lied about this on the stand is the state's position. There seems to be evidence to support the position that he lied on the stand about raising the gun. He was confronted with the exhibit. He denied it. The jury wants to see these exhibits. And I understand there may not be a final ruling on a mistrial until we see what happens or if it's even necessary. And
they had their own expert.
They had their own expert that could have looked at this video, and I'm sure did look at this video, and there were questions at the very beginning of the trial about, and perhaps even before the trial, about the resolution of the FBI plane video, a whole different video. Their expert looked at that. I'm sure their expert looked at this. Their expert must have missed it, that it had been compressed somehow. This is not a resource we had available to us. And I believe the motion for mistrial is inappropriate. I don't believe it should be granted. And coming back to number 5, they're asking to see exhibits that have already been played, and with the exception of the image, exception of 155, were not objected to. And the court has said many times when the state has tried to raise these technological issues, well, there wasn't an objection. And we're asking for the same treatment now that these were not objected to. The defense has had access to the exhibits. They've had access to the drive, that they didn't realize it and we didn't realize it till Friday. That there was some sort of difference is perhaps unfortunate, but they're also responsible for I'll withdraw that. Anything else? So the state believes that we believe all exhibits should go back. Again, I understand the court has concerns over the still image. I understand that might be in a little bit of a different category, but in terms of question number 5, and I'll just, while I have the floor, I'll just go through what they are. The FBI aerial with all person of interest marked, that would appear to be the defense exhibit that they neglected to mark and has now been accepted. The state also has one, which is Exhibit 25, which has Mr. Rittenhouse and Mr. Rosenbaum marked, but not the Zeminskis. So I assume they mean the defense exhibit, but we could send both back or have them come down and view it, however we do that. The drone video is 73. That's the full unedited exhibit that's been in evidence now for over a week. The zoomed in still image, we all have talked about that and beaten that horse to death, so I'm going to skip that for now. Then the full event video in regular and slow motion, that seems to be the drone video, as that is the only video of incident 1 that was played in slow motion, just as the only video of incident 2 in slow motion was Dr. Black's. So expert video was submitted. Our expert video is, I believe this is actually 6 videos that they're asking for, which is the drone video. It's spliced out, so it shows the first third of the incident, the second third, and then up until the end of the shooting, and it's in regular and slow motion, and that's exhibits 581, 582, 583. I'm sorry, S81, S82, S83, S84, S85, and S86. And we believe that the jury should have full access to them. They should have full access in this room. And that's our position. I do not believe a technical reality, shall we say, or an unknown technical incident should result in a mistrial.
How would we object?
Pardon me?
How would we object to something we didn't know existed until it was over?
I didn't find that point particularly persuasive because, but anyway.
It's impossible for us to do that. And everybody in this room that's a lawyer has been a prosecutor. Your job is fairness and being a truth seeker. It's not debatable that it's not fair what happened. We can sit here all day and say it's been played. We didn't know there was another version. How is that reasonable?
Well, I persistently warned the state that, there's a day of reckoning with respect to these things. My feeling is I had my qualms, and I decided, well, I'll let the jury hear it. I think I made the comparison the other day of the breathalyzer, where the officer doesn't have to be familiar with how the breathalyzer does the analysis, but that's a device that has been sanctioned by the courts, and I just don't think we're at that place with this, and particularly if they've got evidence. I didn't see that in your motion about the manual.
We've learned it since I filed the motion.
Well, if they've got the manual, I don't know. It may be. I forewarned you. You've pressed with this, and that's fine. I've let it in, and my view on it now is where we are. We might as well follow through with it. And if they've got everything correct and it's reliable, then they won't have a problem. If it isn't, it's going to be ugly. All right.
I would just note that the defense, I'm assuming they were paying attention to the trial, would have known on Monday when Detective Entremian testified that that version was different.
We're going to talk about it later because I've made the decision. I'm going to be played. You've suggested that it be played here in the courtroom under whose supervision? And
But this becomes the deliberation room for that portion as they watch the video.
I'm going to be in the room with them.
The same people that are in the room with them now.
Well, why come down if they're just going to be looking at? I mean, are you saying that they come down and hear it with all of us in here?
No, I'm saying everyone leaves.
Okay, well, why not just leave them up there?
Because the screen, watching it on the screen that...
I got you.
And that goes, the problem we're talking about on 5 early is the request 5.
Yeah.
We're talking about the
I
problem.
didn't know the last word you said.
The problem we're talking about on request 5 is on the front end so far, and it goes to the same thing with that television, adding the pixels on the back end. So now they're looking at it on a computer upstairs, and I don't know why they're not looking at this on a computer. Meaning 5. I put my hand on request 5.
Well, and how many times? One time? Is that what you said?
I didn't know. I think just as they're... No, I think they should be free to look at it as much as they'd like.
That would be my bias, frankly.
Being laid out.
But the law, we've got the law that you cited the Anderson case. I have ruled in the past, and I'll rule again. The Anderson case is not applicable to images of the event, only to like statements and that types of thing. So, but I'll hear you out.
Judge, that's the, I mean, I'm relying on a Supreme Court of this state's case. I understand that you're separating them, and I'm not here to, I'm just here to tell you that we object to it being played over and over. What I've learned from your case with the videotape or the cassette tape and Anderson, both of those cases talk about not there being an overemphasis on specific parts of evidence.
Possibly overemphasize a video of something. Unless, I suppose, if it's not an accurate video, I suppose then you could. But then you're overemphasizing it when you see it the first time.
That has been the concern of the court in having them when I say them, having the jury have just unfettered access to it. In Anderson and in I think it's Franklin, that was the part of the concern in both cases.
And I will repeat, I think it's the fact that we have to censor what the jury uses to decide. When the founders of the country gave them the power, it has to be censored by the judge. That's really insulting. So I certainly, I'm not going to say there aren't cases where a jury could overemphasize something, but for me to say, well, there's a video that is purportedly an accurate depiction of what happened, and you can only look at it so many times, I'm not going to do that. So they know the risk, and they've assumed it, and so they can watch it. They'll do with it as they see fit.
So I understand they're ruling the videos. We do not object if the zoomed-in image is not sent with them. 155.
Well, I'm going to leave you gentlemen to confer, and as you did before, and came up with a workable.
How do you wish? Should we put it on a drive and send it to the jury, or are they coming down here?
Why don't you give them a drive, because then they've already got the clean computer to work with to put it on a drive.
I want to use this.
And then they'll come down here, and presumably they know how to work it, or they haven't told us they can't. They can come down here, and they can operate it from wherever they're comfortable, and we'll all clear out of here. And okay.
I will work on that.
Okay, you confer and come up with an agreement to which you object. A working agreement to which you object. Now let's do the case of the state against Emmett Zier. Work for them?
Yes.
Okay, good. Where's the DA? Oh, here they are. All right, what's going on is that the parties have agreed on a mode to present over the defendant's objection, the material requested in note number 5, I think. And that's ready to go, and it just needs to be, the right button needs to be pressed, and they can play what they want. And we're going to evacuate this room. Everybody, including everybody. Only the jurors will be allowed in here, and they will be instructed to knock if they want. The bailiff will be outside the door, and the media have to leave. And if you leave anything electronic, the bailiffs are going to search the room. If you leave anything electronic here, make sure to say goodbye, because you will never see it again. With the exception of Court TV's materials that are too hefty to move, but they must be shut off once I've instructed the jury. Any question? Okay, fair enough. Let's ask the jurors to come down.
We need a minute to make sure everything's clear.
Okay, and do you need Mr. Krause here too?
No, but I would recommend that the deputies or the bailiffs walk around and make a visual inspection to make sure there's nothing left behind.
Sounds good. Officers, will you do that? Make sure there's nothing left behind. The jury room while they're doing their work here. Going now. This is going to be very short. I'm just going to tell them what's going to happen, and then the minute we all leave, then everything's got to be shut down. Okay. And the latest we can go today is 5 o'clock. Just so you know, I will tell them then. Okay. Okay, you want me to play some music? And autumn leaves start to fall. Da, 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 da.
Are we waiting for them to clear?
Huh?
Are you waiting for the people in the back to clear?
They can stay because they're still making a recording, but or live. I don't know. But anyway, they're okay. But only until when we leave, they leave. All right, folks, you're here in respect to your request number 5, and what's going to happen is I think it's all queued up, and all you have to do is press the right button, and you can view the material as much as you like, and you can close in closer to the screen if you want. It'll be your call. You can discuss it, and you'll have complete freedom of privacy because we're all going to be out of here, and we've already done a check to make sure there aren't any kind of devices that would pick anything up. Then when you're done, there'll be a bailiff outside this door, and just knock and advise the bailiff that you're done, and then you can return to the jury room. Any questions?
Both screens be.
I believe that's the one. It's going to be that one. Okay, any question? Yeah, ma'am. The court TV? Yes, they are. I permitted them to stay in here while I did this explanation to you, and then we're going to leave and they're going to leave. There'll be nobody in here but you 12 jurors. Okay, no sitting in my chair. All right, anything else? What's that?
How would you know?
Good question. All right, we'll see you in whenever you're